Okay. Good afternoon, ladies and gentlemen. I've updated your report requirement. You have to turn in until by due date set forth in the announcement. I partially modified my previous announcement, so you have to double check when is due date and also how to respond to the requirement. For example, you have to prepare in single space or single space, and also the page limit was imposed. You should not exceed 7 pages, and also how to turn it in, the ways turn it in. So you may put it into my mailbox or simply email a complete report at my email account. Okay. And now we see a Friday, fine scenes. How do you feel this Friday? Are you shown over your vigor or energy because of hard class schedule? Actually, usually you fancy if you finally can will come soon. These days, there's many stories of turmoil. Terrorism is really problematic. There is small scale, other than a 9/11 attack, but it is also public fear in the United States now. Sharply increased. Some factory explosion. What is that? Factory explosion. So I recovered the previous rows. You can see rather a clarified chart, which is simple, but more visionary. So suppose you study. So, and top of chart, you can see Supreme Court of the United Kingdom. And next ranks a Court of Appeal, and you can see High Court of Justice, and also your available Crown Court, Majestic Courts, and County Courts. And for the class discussion, I've excerpted some newspaper articles which advance the scene of the trademark of solicitors. As you see later, there are two sets of professionals in England. So barristers and solicitors are those which you can see some similarity to the institution of Korea. We have two professors which are designed to serve the public purpose of a legal service. 법무사 is one other area where some qualified people serves to prepare a court document and also some distinct value of legal practices, which could be distinguishable from usual course of a lawyer business. We are not exactly sure between these two professions, since there's some overlap area of work. So that is a point of controversy in Korea. But there are some other points distinctive from a Korean context. So there will be further clarified through the progress of this class. This feature shows some person who was accused of some social public resentment. He was already committed some unethical act which aroused public resentment and hostility. Much criticism was lodged against him, so I'm sorry to cite this picture, but for our education purpose, it would be excusable. And so, there is some judicial style. You can see in the picture, he wears a wig. And you can see a traditional look, which emanates the sense of a tradition and authoritative call. So you can imagine some worship, which is prudent and very scrupulous, and also a commanding in terms of respect for law. So they share a same feature with the court at bar. So we call him a barrister. In the previous profession, what I call solicitor, they would normally be of a modernized look. So they wear modern ties, look both the same as a normal citizen. What are the story? And concern of this picture, we have some story. We've been asked this question so many times. It's impossible to put a number on it. In the case of the asbestos survey, the law says common parts are non-domestic and are therefore subject to the law. So in short, the answer is yes. Common parts are generally sold on entrance lobbies, stairwells, lift shafts, but so is the exterior in most cases, as a product of a chimney and service ducts. So even if you live in a house converted into two flats, one up, one down, separate entrances and no communal entrance, you still need to check if you share any parts of building with your neighbor. So I suppose it is a part of communication, which is actually a professional advice in interaction with his client. I'm sure that this kind of practices are usual of the modern time. So you can see some special sections of local TV where you can utilize some assistance, legal assistance from the panels or other experts. It is interesting, and helpful to your study, I guess. Some concerned people form to present a legal dispute, and in response, the legal experts are expected to give some talk about the facts and some relevant provisions to be applicable, and kind of a strategic way to respond the grievances. So, and that mode of interaction now was elevated into areas of internet communication. So some law firms may prepare a homepage and receive an inquiry from concerned people, and they would be a prospective client. This paragraph seems to be that way. It touches on the family issues of family law, non-domestic, and some kind of reciprocity between the adjacent owners of land or buildings, so real property issue or other domestic matters was guided to inform a useful legal assistance. So, we return to the court system in England, and in the previous class, we have a lift from some parts, which is a little, but we have to complete the rest of parts. So, firstly, in this chart, you are unable to see the private counsel, but it is one of the judicial organs in England, which is principally designed to respond to commoners' questions. So it is, in some context, a little political, but also may get a significant weight since it is just symbolic. Actually, many commoners countries now available of the final appeal in this private counsel. About 50 years ago, almost all nations or common countries have a symbolic Supreme Court, which is what I call a private counsel. But that is not the case nowadays, and some Statute Act also endorsed some emancipation of a strictly commoners control. They are interactive and politically bear some implications, but the initiative may also be dubious. Which country prefers to get out of a jurisdiction of private counsel? And so political independence may be delicate in that point. The private counsel is also a judicial evolution of the Korea regions, so long traced back to the 13th century. It was created initially to hear appeals from the Channel Islands and the Isle of Man. So you can be reminded of the previous discussion that there is no strict adherence of separation of powers principles. So legislative and judicial function have some mosaic of a function, operation, a institutional operation to serve the dictatorship of a monarch. Curia regis is exactly the kind of traces you can identify. Later known as the private council, it assumed the role as the final court of appeals for courts from throughout the empire. The royal prerogative was its source of power. The private council's minor local jurisdiction diminished when the scope of the royal prerogative was limited, following the constitutional conflicts in the Stuart period. The private council later refined its unique role as judicial body, limited to hearing appeals from the commoners, aided by the creation of judicial committee, whose members were limited to professional judges, which assumed responsibility for all judicial matters of private council. The judicial committee survives as part of the English court system. Its judges are those private councillors who have high judicial office in the United Kingdom or other parts of commoners. But only a few appointments were made from the commoners prior to 1962, by which time a political change in the commoners had reduced the jurisdiction of the judicial committee. Commoners nations acquiring independence generally established national appellate courts, terminating or reducing appeals to the judicial committee. Canada, India, South Africa, and most other former commoners members have abolished appeal to the judicial committee. A few former commoners nations continue to use the judicial committee as the final court of appeal. Had a commoners' representation been increased significantly prior to 1962, the Judicial Committee might have survived as a far more consequential institution, but never altered its status as a central court sitting in London, requiring commoners' Judicial Committee members to travel considerable distances to participate in deliberations. The relative inactivity of the committee did not demand the full-time presence of its members, and commoners' participants usually did not terminate service on the national court. Once prestigious, this judicial vestige is now of minor stature. Its future is bound securely to the fortunes of the commoners. The process used in the private council differs from that of the House of Lords. Unlike the hearing in the House of Lords, the judges on the private council reach a single opinion. No concurring opinions are written, nor are dissents permitted. The nature of decision differs from an appeal from the lower courts in England. So this is a point of distinctions I've said previously. Actually, in most of national jurisdiction, this practice is required in compulsory fashion by the Judicature or other supreme document. So that is because the minority opinion at one time may shift to majority status. So it encourages to flourish a diverse opinions for more refined and public policy. That is not proper in the context of private council, which is a little different from a unitary form of government. So you can see in international politics there are basically three types of nations, which is a unitary form of government and a federal form of government. For example, Germany and the United States fall in that class. And commoners' council is the subtle and delicate to on the level of intermediate level. So it is like more loose form of a governance. For example, United Nations. It has more institutions and some kind of substantial interplay among the nations. But they have no single context of a national army. And also, they have a prestige and also state rights to represent each country within communities. They have power to independent diplomacy, to raise their voice independently for the international society. So it is not a form of national or federal government, but it is some of a medium of a density and interaction in terms of a institutional formation. So that is in contrast with the United Nations and other international organizations. So WTO or UN are distinguishable from a communist framework. So the court culture and a judicial style comes differently in the context of private counsel. The decision of Judicial Committee of Private Counsel goes to the sovereign, who then conveys the decision to the particular court in whatever nation or communist member from which it has been submitted. In the same manner as hearings before the House of Lords, private counsel hearings are informal and judgment is reserved, because there is an opinion rendered by the court. The judge who has been assigned the task of drafting the opinion will meet with other judges to achieve final agreement. It is time interval to make it disappear. I have to be heedful to prevent. Why? Because so even if there is strong dissent, it will not find expression in the final decision. When the decision has been completed, the final part is read by one of the judges during a regular sitting of the House of Lords at the judicial body. The sovereign does not give assent to the decision in the same form as rendered to legislative acts of Parliament. Decisions of Judicial Committee are accepted by the sovereign at the formal meeting of the full private council. The difference in the process of sovereign consent illustrates the judicial independence of Judicial Committee, an independence which parallels that of the House of Lords in its regular appellate capacity. As noted above, the frequency of reference of appeals to the private counsel is decreasing. So we usually pop up the concept, a judicial independence. So it's a strong tradition we found in the British context, as I've introduced, and common law lawyers or some endurance and persistence to resist against and the power unduly exercised by any notwithstanding the principal virtues of a civic society, long heritage, or kind of a basic concept of humanity, justice, that dynamism should be. So, as noted above, the frequency of reference of appeals to the private counsel is decreasing. The more developed nations of commoners tend to feel comfortable with their own appellate structures, But for some of the less developed nations, having the private counsel as a court of last resort gives additional credibility to the judicial system as a whole. This does not mean that the private counsel will accept any appeal which it receives. So there are also delicate points about a social, the context of social. It is similar to the practice of the United States. So it is selective in some cases where the private counsel accepts the petition of repeal or review of a statute. And actually, the legal culture of England is highly of enhanced form and very civilized to have a lead and exercise influence in terms of a legal development. So for the less developed nations, the private counsel takes a useful role to interact. Being across the sea and increasingly isolated from the culture of newly independent former colonies, the private counsel may not feel able to deal effectively with some issues. So the concern will be revealed in the following excerpts prepared by part of a court of appeal titled Ratio or Process versus King. So let us have some for our understanding. So the judgment of the lordship was delivered by Lord Planck. Lord Planck is also a great judges, who has spelled out a very enlightening court opinion of vested cases, comparable to Lord Denning, as we have seen in the last projection. At a trial in the Supreme Court of Fiji, held before Stuart J. and 5 assessors, Raghu Prasad was convicted of murdering his father and sentenced to life imprisonment. He appealed to the Fiji Court of Appeal against the conviction on the grounds of various alleged errors and other defects in the judges, summing up to the assessors, whose unanimous opinion, with which the judge concurred, was that the defendant was guilty of murder. We have a separate statute between the model of a normal neighbor and a model of the parents, or which is well expanded in terms of a juridical article. For example, the father-in-law may be distinguished treated by a separate provisions. There are differing level of penalty provided by a Korean criminal code. It is usual, however, in common law countries, particularly in the United States, there are no different treatment. I suppose it is one of cultural point we have to consider. In today's newspaper article, I saw the Supreme Court a case schedule. They soon deliver the judgment about a rape between a husband and wife. Do you agree if we can consider it as a rape? How do you see a forceful husband to commit a sexual relationship with his wife? in spousal relations, crime of rape could be established. How do you? So, actually, in the area of substantive law, we may have some viewpoints or tools of analysis from the eyes of comparatives. Why this country does not have the statute between the model parents and a normal killings? Why do these countries have that code? Well, basically, the issue of rape I've raised would be shared by most jurisdictions in this contemporary era. The private and domestic spousal relations should also be respected in some modern sensibility. How do you agree? But are they so? In do you see it complies with the prevailing sense of justice or the nature of things in Korean society? Delicate point. So the practice of judicial committee in the exercise of appellate jurisdiction in criminal matters was assertively stated by Lord Sumner in Abraham versus King. The practice remains unchanged, and the whole passage bears repetition. So you can see the essence of a prior decisions made by a private counsel. So it includes some basics and guidelines about the murder crime. To this, the lordship would only add the court of appeal composed of judges more familiar than members of this board can hope to be with local conditions, social attitude, are in a better position than the lordships to just assess the likely effect of any misdirection or irregularity upon a jury or other deciders of fact in a criminal case. This is all the more so where, as in Fiji, the mode of trial is not the same as in England or Scotland. There is no jury. The trial is before a judge and assesses to the number of not less than 4 in capital cases. The judge sums up to them. So the private counsel usually differs to a specific jurisdiction, particularly because we can see a scope of, a spectrum of differences in legal environment or social attitudes and dominant practice in society. So actually, the culture and legal are keenly entangled each other. So also there is a concern about some civilization of a law. In that context, the private counsel needs to exercise more actively to intervene. For example, there is, particularly in terms of cruel crimes and capital punishment, the guideline should be clarified from arbitrary use of a traditional anomaly, for example, excessive torture and some unconvinced execution of a death penalty. The kind of issue is problematic, actually. Each judge then states his individual opinion as the guilt of the accused. Although permitted to consult with one another, they are not obliged to do so. And the ultimate decider of fact is judge himself, who need not conform to the opinions of the assessors, even though they be unanimous, if he thinks that their opinions are wrong. So Fiji is an unavailable traditional jury system, and also we are not sure if due process concept of law may be ensured. But that is a critical point, usually about common law judges, whether it is offer a jury trial, or safeguard the liberty of each individual on due process. Actually, we can say some political justice in this contemporary times. We said a private counsel in the context of a communist politics. And also we have tip about a judicial independence. But ironically, usually in the practice of a government, the political aspect would come rather forefronted in many cases. For example, you can see the practice of Guantanamo camps of concentration. So national security will seem more essential for the policymakers and many concerned national officers. So the Supreme Court in the United States also favors the kind of political justice, which is very unusual to a normal context of just a business. But it's actually a reality in many cases. The field of comment upon evidence that is proper to a judge in summing up to jury in trial in which they are collectively elusive deciders of fact is not necessarily the same as in summing up to assessors whose function it is to help the judge in making up his own mind as so ultimate a determinant of fact. And now we are required to review the special cause and treatment rules. Nearly every advanced society, whatever its legal tradition, the price of its degree of advancement seems to be extensive government regulation of the lives of citizens. The ordinary courts cannot bear the burden of this additional load of dispute resolution. And as noted above, they are often viewed as inadequate to deal with these issues because of the cost, delay, and procedural complexities they have accused the law along the path of development. The national response has been to create new structures to deal with these issues. Many questions around these structures. Are they to be given the status of cause or consider lower level tribunals? Will there be an appeal allowed into the regular court system? So this is an important point if the drafters of institution are exploring about a special court system. It is integrated into a final authority of Supreme Court, or appeal should be deprived of persons involved in judicial proceedings. That is an important question for a constitutionality of a design modality. Who will have the right of advocacy in this court? Will their jurisdiction infringe upon the regular courts, or are they truly limited to new issues? One often sees writing and hears lectures on how the materials in a text or casebook, the curriculum of law school as a whole, or general focus of attention is on the very limited area of the regular courts, and even more specifically, the appellate court. People's everyday lives may be affected more by the medium of tribunals than the regular court. So the business of government is a professionalized and very now garners a scope of a public affairs, which is divided into a myriad of government branches that are realized in the administrative branch, executive, but that is not exactly the case for the judiciary. We usually refer basically to the ordinary courts and several special courts of tribunals. But that is not definitely a stalemate, and the court system, although largely coming lag behind, many cases of leapfrog or a improvement in some, a contrary improvement in some other substantial points of consideration. So we have some many of the special courts and tribunals in England, which is not the case, I suppose, in Korea. They may be denied social security benefits. A person's small store is fined for sanitary violation. Price controls hurt their profit. The son is denied a deferment and must forego college. The daughter is denied a real estate license. But the structures which deal with these issues are given comparative risk and attention. It is a practice we have to consider seriously, perhaps not so blindly. Though the special courts and tribunals to come into people's lives so frequently, we nevertheless tend not to perceive them as institutions to which we turn for many major issues, nor do we consider them part of the essential structures which make up the central fabric of our system of justice. Those roles are reserved for the regular courts. With regard to the civil courts, that is where we go if are seriously injured by another in an automobile accident. So you often be heard of teachings and guidance from your law professor. You have to be specialized. That is exactly true if the modern public business developed into a kind of a professionalized diversification, and expertise is usually required to address the difficult issues or social or public issues. And it also contributes to creating a new area of market. We now have some pioneering department in the government, Future and Creation Ministry. What is that? So we have to explore a new area and innovate. Innovative mind is actually demanding in many purposes of a society. Legal occupation is not exception. We have to explore the areas of law to expand our justice business into the areas of penumbra where the citizens suffer. They have legal issues, but actually they are served, since their injustice may be injured, sense of injustice may be injured, but usually reluctant to raise that issue as one of a legal matter. So we need to cultivate and expand the execution of job duty into a new area. Do you agree? Usually, many lawyers are grumbling about a increase of attorneys, so they are factored for the poverty and the shrinkage of a profession in job market. That is true in some contexts, but more importantly, we have to be innovative. There are many areas of a new justice, competition law, or other extended role of a government pertaining, for example, social security, public education, and labor law areas, and unemployment questions. And recently we have many cases concerning a bankruptcy, so merger and acquisition, usually produce a layoffs of unemployed workers, and also push the existing forms and enterprises into bankruptcy. So the legal aids may be available for that predicament. So we the class will not be closed in next week, and we usual course of dealing for this class. And in the beginning of class, I am reminded of a risk report requirement. So you have to visit the homepage as usual and to check out with the announcement, prepare for your risk report, and leave your name for with other peers. Can you name? And you may leave. So, where difficult or property disputes are resolved, such as rights or ingress to our homes, they loom large in our lives, as being the cause where the really serious issues can be heard. They may be where we take our appeals from either lawyer, regular courts, or special courts and tribunals. This touches upon a sensitive issue which is resolved in different ways in different systems. That is, to what degree should the regular appellate court reserve jurisdiction of appeals from all forms of hearing bodies. The audit courts also are essential to our perception of the use of the legal system for dealing with crime. Almost any charge we are likely to face, from running a red light to the most serious felonies, go to the regular courts. There are tribunals which have the ability to levy fines for violations of law, but again, a perception of the kinds of activity over which the regular courts have jurisdiction tends to elevate the regular courts of the tribunals. What we consider subordinate tribunals in our system may be given far greater status in another. So you can see the needs of a special tribunals, and also there is a practice in Korea, which is different in the context of institutional arrangement. You know, we have a unitary system of a administrative review instituted within the executive. In United States, also it is prevailing practice to see many adjudicator body in the executive branch. For example, International Trade Commission comes as one example. And also, many independent counsel assumes the role to execute the adjudication, a judging, and they conduct a brief review, which is similar but concise against the forms of a court proceedings. But they made a decision by subsidizing attendance from a counterparty in interest. And so they proceed. And of course, there should be appeal to the normal court-like, hierarchy. So more a stern judicial review must be ensured in context of a constitutional framework. So that is one legal issue usually challenged in the United States, the jurisdiction of the United States. So they term two types of codes, Article 3 code and Article 1 code. Article 1 code usually falls within that class. So legislature in their needs to address this public question or issues may institute some core-like body, what you call a domestic body or independent counsel. That is not exactly the same nature body in contrast to Article 3 code. So the jurors in Article 1 code may not be ensured of lifetime tenure or other shields of a constitutional protection. They are not constitutionally safeguarded, just a product of legislature. So the interaction and the framework raise a delicate point. There is also a similarity found in a Korean jurisdiction. We have a tribunal, special branches, but it is a little unified in its nature, which is operating in the line of unit control. And of course, the judicial process will finally ensure against the midst of justice. What do you consider? Subordinate tribunals in our system may be given far greater status in another. Consider, for example, the West German hierarchical code. Alongside the hierarchy, which possesses civil and criminal jurisdiction, are other hierarchies, not just all lower courts, but full hierarchies which ascend to their own final court of appeal. One such hierarchy is Social Security. It is co-equal in this institutional structure with the civil law. It does not have such status in English system, nor in the United States. And even in West Germany, if one asks if they are really perceptually co-equal, the response is likely to be no. The civil hierarchy is given greater stature. It is less parity because of the great reverence for the civil code and the social security laws. In the same way, we have greater reverence for the sources of law, which govern civil matters in the common law system. Precedent of the courts and legislation than we have for the laws which govern social security issues, domestic rulings, and legislation. Whether one agrees or disagrees with the above, we must consider the tribunals. My comments above do not suggest the lack of importance of the special courts and tribunals and common law system, but offer some reasons why we tend to discuss them after we discuss the regular courts. Perhaps the most visible is the restrictive practice code, hearing a broad range of issues related to monopolies and restrictive practices. So they are substantially more important in many senses. it is the most important court in England to use an Albany opposition of judges. Professional judges from High Court, Court of Session in Scotland, Supreme Court of Northern Ireland, one of whom serves as president, share the bench with a layperson, with 10 laypersons who possess special knowledge of industry, commerce, or public affairs. But the special courts do not share the respect the bar calls the ordinary courts, or even less stature as the numerous tribunals. The procedures are less formal, or more rapid, and less expensive than proceedings in the regular courts, but they are criticized to deny individuals their right to appeal before the ordinary court. Lay participation on tribunals is far more extensive than in the regular court. Solicitors may appear as advocates, but even they are not required in many tribunals. The development of special tribunals with lay judges is viewed by some as a way of preventing social legislation from being excessively strictly constructed by the conservative English judiciary. But the judiciary has reacted. The Tribunals and Inquiries Act 1958 increased a professional judicial control of the tribunals, foremost through the participation of Lord Chancellor in appointing members. Further control is exercised by channeling appeals from tribunals to various parts of the Supreme Court, usually King's Bench Division of the High Court. Dispute resolution in England by the Ordinary Court as a right continues to be eroded. Any encroachment on the role of the Ordinary Courts by administrative tribunals is generally weighted very carefully. No formal recognized separate court hierarchy has developed for private and public law issues, as exists in many civil law nations. But there is nearly one for some public matters, such as social security. Administrative justice in England, viewed by many, particularly the organized bar, with less than reverence, nevertheless continues to increase in scope and has a notable effect on the lives of all English citizens. So now, we live in a time of expansive public domain, so it's delicate, and the code usually goes to be some technical in various fields. For example, so monopoly is an area of monopoly law, and also the court judges may not perform their role without the expert assistance. For example, in context of dovetail, where the economic group, which is instituted to support the panel and appellate body. The legal dispute involves very difficult economic points of expertise. Subsidies agreement is one example. How to assess the amount of subsidies? It is really difficult. Subsidies usually take the form of a transfer funds. What will transfer funds mean? Usually they are not a direct transfer of visual funds. We may grant some dollars to enterprise. That is not the case for usual government practice. Government may make some laws or regulations or a special enactment to support the enterprise, which is sanctioned by a subsidy agreement in WTO. And WTO needs to respond by countervailing tariffs, or they may make a recommendation about abolishment of the unfair institution. Then they face with the issue, the amount of the subsidies. How the laws make contribution, which is special and discriminatory against a groups of a industry in the context of global market. So they need a economic expertise, but it is they're usually trained experts, legal experts, who are short of the exact calculation of the economic impact. So they have long been aided with a expert group. And actually, now we live in very complicated era. So the business of justice is also entangled with that dynamism and pose challenges in a special area and difficulties. So I'm sorry to renege on my promise. I have to get it finished, legal education, but I have to stop here. There will be for the next class. And any question? Then I close this class. And have a good weekend. Thank you.